The real reason Supreme Court cannot accept Atiku'S fresh evidence. Tinubu and Senate leader speaks. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel. President Bola Tinubu has advanced reasons why the Supreme Court should reject the purported fresh evidence Atiku Abubakar and his party claim to have obtained from the Chicago State University CSU in relation to his academic records. Tinubu argued, among others, that the Supreme Court could no longer at this stage assume trial jurisdiction in the case since the 180 days allocated for the hearing of election petition has lapsed. He added that not only are the said new evidence strange to the proceedings having not been presented by the trial court, Atiku and the People's Democratic Party, PDP, who were joint petitioners at the Presidential Election Petition Court, PEPC, did not challenge the outcome of the last presidential election on ground of forgery before the PEPC. Also, the majority leader of the Senate, Akpabio, noted that Atiku and the People's Democratic Party never pleaded before the PEPC any document or the position from the CSU in support of their fourth ground, which spoke about Tinubu's alleged non-qualification. Bamidele then said if they had done so, Tinubu would have had the opportunity to respond appropriately, including raising the discrepancies in Atiku'S credentials. These are contained in the counter-affidavit and written address filed by Tinubu through his team of lawyers led by Wole Olanipeku's son, in response to the application by Atiku and his party seeking the permission of the Supreme Court to introduce fresh evidence in the appeal. Atiku and the People's Democratic Party had appealed the September 6th judgment of the PEPC dismissing the petition challenging Tinubu's victory at the February 25th presidential election. Tinubu, in the written address, argued that the Supreme Court cannot accept the written disposition of the registrar of the CSU, who was not a witness before the PEPC and whose written statement was not activated through oral evidence as required under Section 411 of the first schedule to the Electoral Act 2022. The mode of oral examination is provided for in paragraph 41(3) of the first schedule to the Electoral Act, to wit, adoption of written deposition. Where a written deposition is not activated by oral examination of the deponent before the court, same will not be acted upon by a court. It is not in doubt that the deponent of the deposition sought to be introduced as additional evidence was not orally examined at the lower court. The appellant has not made a case for the court to override the provision of paragraph 41(1) of the first schedule to the Electoral Act or refer to any law permitting the use of the deposition outside the confines of a paragraph 41(1) of the first schedule. Appellants are attempting the impossible, thus they have not stated whether the evidence is documentary or oral evidence because it fits into neither. He also argued that the Supreme Court no longer has the power to assume trial jurisdiction on the petition by Atiku and the People's Democratic Party because the 180 days allowed by the Constitution for the hearing of election petition lapsed on September 17th in respect of this petition. In the circumstance, this Honorable Court is without the bias to consider the said deposition either as oral or documentary evidence, more so when same was not considered by the Court of First Instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria. He argued that the case presented by Atiku and the People's Democratic Party is worse than the situation in the case of Tofomor W. Ajayi, SC CV 1526-2022, where the Apex Court said a judgment delivered on January 27, 2023, declined to invoke its power under Section 22 of the Supreme Court Act as being sought by Atiku and his party in their latest application. The court will note that the above decision presented more valid basis than this application for the Supreme Court's intervention because therein the issues had been raised at the lower court without resolution. The situation of this application is worse because, admittedly, it relates to fresh evidence obtained after the judgment of a lower court, and the date of a filing of a motion was and is outside 180 days of the filing of the petition. Admission of fresh evidence can only proceed from the combined provisions of Section 22 and 33 of the Supreme Court Act. The provisions of under 2 Rule 12(1) of the rules of this Honorable Court, pursuant to which appellant's motion has been brought, circumscribe the receipt of fresh evidence within the circumference of Section 33 of the Supreme Court Act. Hence, for this Honorable Court to be able to give effect to Section 33 of the Supreme Court Act, which is the bedrock for other 2 Rule 12(1) of the jurisdiction of the lower court, must be alive. Unfortunately for the appellant, however, this jurisdiction died as far back as 17 September 2023 upon the expiration of 180 days from the date of filing of the petitions by the appellant. In recent times, even in very dire and pathetic situation, this Honorable Court has been faced with supplications from parties to consider the merit of the actions which has left unattended by the trial court after consideration of threshold issues. However, being bound by the provision of Section 2856 of the Constitution, this Honorable Court has consistently declined. Tinubu, who is listed as the second respondent in the appeal, contended that the application by Atiku and PDP did not satisfy the condition in which the court can accept fresh evidence from the appellant. We reiterate that the new document disposition was neither pleaded nor listed as the lower court. Even in regular civil proceedings, the court will still be required to fall back to originating processes in assessing the extent of its powers. 5 conditions or requirements must coexist before this court can grant this type of application, as decided in a host of authorities. In summary, the conditions are that the fresh evidence could not have been obtained with the reasonable diligence at trial. Such evidence, if admitted, would have important effect on the subject of the appeal. Such evidence, FSA, is apparently capable of being believed. Such evidence would have influenced the judgment of lower courts in favor of the appellant had it been available. And if such evidence is admitted, further evidence from the opposing party will not be needed. Aside from the fact that there was no pleading whatsoever in the appellant's petition before the lower court relative to the fresh evidence which they seek to adduce, may we refer the court to paragraph 14 of the counter affidavit, where the second respondent had reiterated the fact that there is no issue was joined as between him and the appellant on this purported evidence which they seek to tender. Wow. Well, on top of this matter, I go say make everybody take a chill pill. Everybody don't turn lawyer, don't turn Supreme Court lawyer. Make them do it in come outside and do what make them come outside, come talk on top of this matter. If not, anything we will talk, not just our own opinion be that. Alright, and that's not to have come to the end of the news. So thank you for tuning in to listen. Until I come your way next time, enjoy.